Welcome to the Downtown Partnership Downtown Impact Series. Thank you to Nancy Park, who is with us today for our final webinar on guidelines and tips for commercial tenants in navigating COVID-19. Some quick housekeeping before we get started. You have a Q&A function at the bottom of your screen. Please use that to submit your questions. We will hold questions until the end. So if you notice questions throughout the webinar, continue to add them here in the Q&A, and we will have an opportunity at the end of the webinar. With that, I'd like to introduce Nancy Park, board member of the Downtown Sacramento Partnership and partner with Best and Krieger LLP. Nancy, take it away.
Hi there. I'm going to share my screen now to get my slide presentation going. Can you see it?
Yes.
Okay, good. All right, so I think Emily had a title for it, but I have a subtitle which is Maintaining Good Landlord Relations in COVID Times and Tenant-Focused Best Practices, so that we focus on the tenant side of things, but maintaining a good relationship is part of this presentation. So we're going to go through what some of the issues are and then some of the problem-solving techniques and some approaches to help tenants deal with some of the issues that are going on right now. All right. Okay, where's my screen? Oh, my disclaimer didn't show up. Just want to mention, I'm not giving legal advice here, not allowed to give legal advice via webinar, but this is practical advice for you. So there is a disclaimer here, of course, as there always is. So it's kind of been a new world since March 17th, as we all know, and a lot has gone on. Government orders have turned stuff upside down, operations as we know it. Here we are 4+ months later, still some government orders going on. And likely more to come depending on where things go. And so we really need to look at, what are we doing immediately in the short term, the next couple months? What are we doing, over the next year or so? And what are the long-term implications of our actions? So we have, currently there's some local and state orders, and actually a couple things expired. Last week. For instance, the current state eviction ban expired on July 31st, but the emergency order is still in place. The Judicial Council, which is the court system for the state, prohibited evictions until 90 days after the emergency order is lifted. So that prohibition is still on. Sacramento has a moratorium for evictions, which expired on June 30th for office and second floor retail and July 28th for first floor retail. And tenants have 120 days from the expiration of those moratoriums to pay back rent to avoid eviction. But while the courts are still closed, there's really no ability to evict. The Judicial Council can actually open up the courts at any time. They are not limited to the 90 days. It's when they want to, but currently it's 90 days after the emergency order. There are orders that are being issued all the time, and so we never really know. Sometimes we get a heads up, but it's good to always double check to see if any new orders have been issued, just in case that you are not aware of them. So check the websites of the city and the state for new government orders. So one size does not fit all. We need to be creative in looking at solutions. And so recognizing there are differences between various property types, different tenants. There are national tenants, there are chain tenants, there are local tenants, franchises, solos, regional, multi-location local companies. There are tenants which are subject to full closure, such as nail salons, and others are on reduced operations. Some gyms are able to operate in open air, but not inside. And some, restaurants are able to do takeaway, but not dine in. And then there are other entities or other businesses who have closed and said, we're not ready to open. We just can't figure out a way for us to operate safely, even though the law allows us to open. So closure by choice is what I call that. Offices versus retail versus industrial. There's all sorts of different operations, and the approaches really should vary for each. The approach to how to try and deal with your landlord and what solutions might work are going to vary. The external factors which are really affecting things right now, again, no surprise to you that the economy has slowed. There are certain economic incentives and relief funds available. There are some grants that are local. There are loans. There are PPP loans, and the city had a loan program as well. We've had vandalism and political disturbances. This has had a very chilling effect on neighborhood walking and attitudes. There's fear and uncertainty in the customer base on, should they be going places and interacting with others. There's fear and uncertainty in the tenants as well as to what's going to happen next and what they're going to be allowed to do. So in my approaches that I'm suggesting here, I do have a couple of assumptions. One is that there's a good faith desire of both the tenant and the landlord to work things out. And also that the landlord has the ability and the resources to offer some relief or can work with their lender if they have a lender. Also, that tenant has a desire to stay open and continue in business. The goals would be a mutually satisfactory and workable relationship with the landlord, that both the landlord and the tenant have economic prosperity after the arrangement, and that there's no loan default for either the landlord or the tenant. So some of the things, sometimes it's hard to know what the other party is thinking or what their standpoint is. You generally know what your situation is, but sometimes you don't really know what the other side is. So, the landlord might have property debt that requires monthly loan payments. Some people don't have any loan, but many have very high leverage, and that may color their ability to allow any sort of accommodation. They have other operating expenses to pay, including property taxes, insurance, utilities, security, and maintenance. Some of these are passed through, and some of them are not. How full their building is, whether there's already vacancy, and if they're already paying all the expenses or passing them through. If a landlord fails to pay some of these expenses because they've given some accommodations, then this might affect the property if they're trying to cut expenses. They may not understand the tenant's business model, not at all. They may just be completely ignorant about some of the business and how it works and how the income is generated. They may not know or understand what tenants' resources are, how the income flows, or what the customer base is before the pandemic or now, and how that's changed. The landlord may rely on the property cash flow as their primary income. They may be a retiree and this is their entire retirement income. Those are some pretty significant differences of perspective from the tenant. The realities that tenants may be facing are that some tenants may have been sort of right at the edge or running at a loss. Maybe they were a startup or things might not have been going boomtown before the pandemic. So this may be the last straw. They may not be able to keep going. And many tenants have a high risk for continued operations, for being able to continue their operations because they may be undercapitalized and have a lack of resources, or going forward have lower revenue and higher expenses, and that it just doesn't work. So one thing that you may not think about, or you may think is a little bit unfair, is that tenants' behavior and attitude counts in landlords' eyes. It's a lot about perception. So tenants' actions to restore their business, to get a PPP loan or scramble to try and make something work or operate at the maximum legal level in order to survive are all going to be judged by landlord and also may weigh in their judgment on how or if they offer relief. If they feel like the tenant's not really trying and the tenant's just trying to push it to the landlord and have the landlord carry the burden, the landlord is less likely to offer relief. And if the landlord perceives a high level of effort they may be more likely to offer more accommodation. Again, this may seem unfair, but there is, a subjective factor here. It's in their eyes and their ability to provide the relief. A landlord wants to see that the tenant is as committed as the landlord in the success before offering the support. So again, if they feel like the tenant is not trying as hard or trying to place blame or put all the burden on the landlord's side, it's not going to fly. And then the whoops, I went backwards here. Hold on. Shoot. Oh. I actually have this, there's a typo here. I say landlord wants proof of inability to pay or perform. Actually, no, that's not a typo. If you say you can't pay, the landlord wants proof of that. So if you say, I just can't pay my full rent, well, then you need to say, okay, it's because I have no revenue and I don't have any resources. The capital of my business, I have nothing. So you're going to have to prove that to show that. Okay. So one of the things before asking for accommodation, or after you ask for accommodation and are told, hey, you need to give me some information, you need to actually prepare for that request. And so it's going to take some work on the tenant side. You really need to look at a budget and sales and income projections. So presumably, as tenants, you were doing financials before the pandemic hit and had a good idea of what your sales and income were and what your expenses were. Now you need to look at what will they be going forward. Now, this is a crapshoot. You really don't know what they are going to be going forward, but you have to make some projections. So, for instance, you kind of have to think back on, well, okay, when you started up, what was it then? Well, you had to take a wild guess. If you had to take a wild guess that I'm only going to be able to do half of my revenue or 25% of my revenue because I'm only allowing 25% of my customers into the store now, then that's the premise upon which you're going to start, your first month's revenue, maybe a second month's revenue. And then maybe you can think, well, the third and the fourth month, maybe things are going to start to pick up because the pandemic maybe is going to be slowing down and I'll be able to get more. So month by month, you need to sort of show and figure out what that ramp up might be for sales. And then also look at what your increased expenses might be because of extra cleaning, or reduced hours or CAMs or other things, additional expenses your landlord might be passing through because of whatever, new window replacements or whatever because of looting. You need to look at what those expenses are. So it's a little bit, again, like a crapshoot. You have to try and make some projections. And it may only be a break-even scenario for tenant, for you guys as you look for the first few months. And you have to look to see, is there light at the end of the tunnel? After 3 or 6 months, if you can survive that long at break even, is there light where you can see things are positive? And that's looking at the rent at full level. Okay, if you can't do it at the rent at full level because you are at 25% revenue, what type of rent does look sustainable? What can you survive on for the next 2 months, for the next 3 months, for the next 6 months? So those kinds of projections, you might have a low, a medium, and a best case scenario and look at what that might be. Those are the kinds of things you're going to need to try and show your landlord. Look to see if maybe a percentage revenue model might work where you are giving a certain percentage of your revenue every month instead of the fixed rent that was there before, to see if you can find a workable rent that pays for, that gives something to the landlord and then also allows you to operate and cover your expenses and the labor for you to continue. This may show you that you can make this work, and you can also come up with a number that then you can present to the landlord and say, this is what I can do if these are the projections. And if things are better than this, then I can do, I can start to pay back that back rent. But if things are worse, then I'm not going to be able to survive. So I need some accommodation. So looking at those numbers is really critical. A couple other things to consider. The some businesses have found that there are some new revenue sources or business opportunities that have come out of this, where they can look at selling things of a different nature or on the side or in different hours or in different formats that virtually, for instance, instead of using bricks and mortar, that have generated some income. So they have been able to survive on some additional revenue. So these are some areas that you need to count that into the whole when you're looking at, all right, how is my store affected? So normal projections, just saying, hey, my sales were this before, and so that's what, and my rent was this before, and that's what's going to be going forward. That's pretty unlikely right now. There are very few businesses that are operating at the same level as before. And so again, considering a percentage of sale or a rent ramp up period after reopening is one of the ways to try and come to some realistic number that allows the business to sustain itself and the landlord to get something, and then have those interests balanced. It's not a pretty picture in some cases, and in effect what you're doing is asking the landlord for a loan or for them to carry that unpaid rent, and you may be asking for forgiveness of some of that, or you may be asking for it to be deferred, for it to be paid over a longer period of time. But what I wouldn't propose is that you say, oh, I'll pay it back over 6 months. It will be too much. It would be like doubling or tripling your rent to try and pay it back over a short period of time. You really need to ask for a longer period of time to pay back anything that's deferred, and ask for no interest. Ask for an earn out if things work out and we come out of this next year, that it'll be over a longer period of time. You may need to seek additional financial resources such as an investor or a loan or help from friends or family to bolster the business, a second on a house, or something like that to try and bolster the business to make things work, because essentially you need the cash to operate. If the tenant does have a PPP loan, then the tenant should pay rent for the loan period to accommodate that, and they shouldn't be asking for accommodation on the rent during that period, because the PPP loan is exactly for that purpose. It's for employee, for 75% of it for the employee payroll, and 25% is for the rent. Okay, so once you have the plan, communication is key, or even before you have the plan, communication is key. The parties need to reach out to each other. Silence can mean dread or fear or avoidance of the issue, sticking your head in the sand. If you aren't talking to the other side, they are wondering what is going on. And while it's a little bit like, I don't really want to hear the bad news, it's always better to face it up front and say, hey, I don't really know what my numbers are, but I'm going to be working on a plan in the next week or 10 days with my accountant. I'm going to come up with a plan. And can we talk about it? Can we go through this? And can we try to work something out so that I can survive and you can survive? The parties have to want to work with each other. It's not a one-way street. So just saying that, hey, can you forgive my rent so that I can continue to do business for the next 6 months, and then everything's going to be hunky-dory after 6 months, and I'll start paying full rent again and not have to pay back anything, which means the landlord's bearing the brunt of the entire thing, is unlikely to be received well. They're going to be looking for both sides to, a landlord that's smart is going to be looking to figure out how both sides can go forward and work together to work it out. They may not forgive rent, but they're going to try and work out something where maybe they can help to carry the burden for a little while and then have it be paid back over the long term. But this is a crisis of no one's causing right here. This is not landlord didn't cause this, and tenant didn't cause this. And so the risk of operating a business is that there are going to be some losses. The risk of owning investment property is that there may be some losses. So both sides have some risk in the transaction, and both sides need to work together to try and share that risk and share that burden so that both can be successful in the long run. So a business plan and the projections and some honest discussion are the key to finding the solution. But again, it does require both sides to want to work together. So some of the other possible solutions and landlord assistance, some of these, cost some money and some of them don't. Additional signage, we're open. That's something that either party can provide or help with in terms of, where it is and how big it is, and, try to generate some traffic. A landlord can help with some expansion or modified facilities if reopening is possible. So offering sidewalk space or alley space, if outdoor activities are available, being more accommodating in some common area expansion, if at all possible, to try and allow the business to open and operate. So the rent deferral I mentioned and an amortized payback, you want to be really careful about somebody saying, hey, you can, I'll give you 3 months rent deferral, but then you're going to have to pay that back over the next 3 months. It's going to be very, very difficult for you to double your rent, on 3 months where you just opened up. So unless you get some help by a loan or some capital injection, or you have some resources, that's going to be pretty tough. So you should look for a longer term amortized payback. So I've seen some landlords forgive their CAMs for the close down period. I've seen some landlords allow for forgiveness and then, or actually a rent deferral and then a payback. So some tenants have taken the landlord up on the rent deferral, and others just figured out a way with other resources to just continue to pay. They didn't want to have to do the payback later. Use of a security deposit as a short-term cash resource is one kind of tricky issue. Most landlords are not going to want to do this because they do not want to have the security deposit go away. And it's really just a robbing Peter to pay Paul kind of situation. If you use a security deposit to pay the rent, it's just a short-term source of cash. And the landlord is going to want to have that security deposit back in case of default. So most landlords are not going to be all that receptive to that unless it is kind of a last resort. I've already mentioned sort of a ramp up rent or a percentage rent. That is a real solution that is probably most realistic for most tenants that are going to open up in some partial way, if the landlord is amenable to that solution. A landlord may require a personal guarantee if it wasn't there before, or they might ask for another guarantor. They might ask for additional security, in the form of cash or a letter of credit or a second on a house or a second on another property. They may be looking for information from you on what other resources you have, and they may also require that you have that you provide full financials of the, well, it's not going to be surprising for them to ask for full financials. I think I've mentioned that already a couple of times, that proving that you have the inability to pay is part of this. And also in your business projections, they're going to want to see your financial statement. What are your assets? What are your liabilities for your business? And they may ask for your personal statement as well. So, and that's where a personal guarantee might come in. The thing about the financial statements is that some tenants are reluctant to give those, but it's entirely reasonable for the landlord to ask for them, because the tenant is asking for financial accommodation and saying they can't pay or they shouldn't pay, and the landlord doesn't know whether this is true or not. And again, a landlord may not understand what your income situation was or is, and isn't likely to just believe the face value. So this is the time when you have to share. And if you want accommodation, you're going to have to share. And if you don't want to share, it's going to be unlikely that you're going to get the accommodation that you might have been able to get if you shared. So this, again, this may seem unfair, but it is the reality of essentially asking for a loan. So it's kind of like if you go to the bank, you can't just say, can you give me some money, without saying, here's what I have already. The bank's not going to just take you at your word that you're good for it. They're going to say, well, okay, well, show me what else you have and how successful you've been. And they'll run credit on you. So it's the same thing here. Landlord, if they're going to give you accommodation, they're essentially giving you a loan. So they may ask for, a landlord may require full performance in exchange for forgiveness. And what I mean by this is they may say, hey, if I'll defer your rent, and then after a year, I'll forgive part of that if you're still open. But if you're not open, you're going to owe it all. They'll have the ability to collect from you because remember that a lease does allow a landlord to sue for damages after a lease is defaulted on. So that kind of earnout or forgiveness versus full performance are definitely clauses that a landlord might insist on. A tenant, but you as tenant should ask, if you stay in and you're successful after a certain period of time, you should ask for, hey, will you forgive part of that loan if I continue to be there, a year or 2 years or whatever. Asking for some level of earnout or forgiveness is not an unreasonable ask because you've put in the time and the effort and you've made it work. So one of the things when you're doing this business planning is you have to figure, well, what is the break point? Because if things just dribble along, at that 25% level, at a certain point, there are times when, you kind of have to say, this isn't going to work. So you do have to be honest with yourself and your resources and know at what point the cutoff is. So consider that in your analysis. That isn't necessarily something you would share with your landlord, but it is something that you should talk about honestly and openly with your co-owners if you have them, or with your accountant. And getting good advice from an accountant is wise. If you work with somebody, you should be working through this and what the tax implications are of the business plan. So also, we don't know where things are going. And so some decisions you're just going to punt on. You're just going to defer until later and say, I'm not going to be able to deal with this now. We're going to try and figure out and come to some short and midterm solution. And then the long-term solution, we'll deal with later. So not everything can be solved at once. If somebody says, well, what are you going to do about the renewal that's in 18 months? Well, you know what? I can't decide that now. I'm just going to have to leave that. Are you going to exercise your option? I don't know. And if they say, well, your deadline is, at now, you might just have to say, well, I'm just not going to deal with it. I can't do it. So it's okay to defer some decisions till later in order to avoid, committing to something that is more than you're willing to deal with. So talking about some of the best practices here, providing those business plans and financials. This is open kimono time. This is the time when you need to share. You need to share what are those financial numbers, what are those business plans, be honest about it. Again, if you do have a break point, I wouldn't necessarily share that, but I think that most landlords are pretty experienced in reviewing tenant financials, and so they will be able to understand what you're presenting. Seek advice from accountants on financial projections. Talk to legal counsel on what your lease actually says. If you are curious or don't understand what your remedies are if you default, what your remedies and what your liabilities. And monitor the government orders to understand what your operating environment is and how those are changing from time to time. If you do make an arrangement with your landlord, make sure that it's in writing. Even if it's an email that you send and they confirm, you at least have it in writing what that is. It's better to have a signed writing. It's better to have something that's drafted by an attorney, but even if it's just, an agreement that you guys draft together, try to make it in plain language that's using business terms, use numbers where you can, make it as clear as possible, and make sure that you talk through what that means to both parties so that it's really clear what the intent of the parties are. Oral agreements, not so good. Written agreements are best. If you have long conversations, go ahead and summarize those and send that summary saying, this is my understanding to the other side. And then check in often with the landlord so that they know what's going on. If things are going really well, let them know. If things are going really poor, let them know. It's better to be upfront about this than it is to have a big surprise that's terrible, without any communication whatsoever. So I wanted to touch on bankruptcy a little bit, just so that some people might be thinking about that. If somebody was, if an eviction had already been filed on somebody before a bankruptcy filing, so again, right now evictions are not able to be filed because of the prohibition on evictions statewide. But if somebody was, if there was an eviction filing and then the tenant went and filed bankruptcy, that pre-bankruptcy filing eviction can proceed. But if a tenant files bankruptcy, a landlord may not file for eviction after that filing. Within 120 days of the filing, the lease has to be either assumed or rejected by the court. If the lease is rejected, then the breach of the lease is capped. So the damages are capped at the greater of 15% of the remaining term lease. I'm sorry, 15% of the remaining rent for the term of the lease, or 1 year's rent, plus any damages from the pre-filing. So if you were delinquent on rent before that pre-filing, that would be added on top of the 15% or the 1 year's rent. So this, if you had a long-term lease, you can cap, you can figure out what your damages would be pretty easily. If the lease is assumed, then all defaults must be cured and back rent must be paid. So if you were 3 months behind, then all 3 months would have to come up with, would have to be paid, and then all rent would have to be paid from then on. There's no modification to a lease. So bankruptcy, it's an all or nothing kind of thing. So it does not modify leases at all, just in case you were thinking this was a way to modify leases. And then there's something called an ipso facto clause, and that's really, within most leases, there's a clause that says, oh, if tenant files bankruptcy, then the tenant's in default and the landlord has certain remedies. Well, those are basically unenforceable once bankruptcy is filed. So the bankruptcy court rules and the lease does not rule in that event. So you don't have to worry about being in default to your lease because you're either going to be accepted or rejected under the court. And you can ignore that ipso facto clause, which is usually part of the default clause of the lease. But essentially, really, if you want to file bankruptcy, you really need to consult a bankruptcy attorney because it's pretty complex and it's very expensive. So it's not something that I recommend, although it is the right approach for certain really, really, really upside down situations or for a reorganization. But it's not something where, it's not for everyone. So just keep that in mind. So one thing you should know are things that landlords can't do. So if a landlord is doing any of these things, you have to realize that they are not appropriate or illegal. So a landlord cannot just lock you out. A landlord has to go to court to get you out of a property. So they can't just lock you out. That would be illegal self-help. They can't use intimidation or threats of utility cutoff. They can't harass you regarding throwing you out or things like that, personal harassment. We call it self-help, but again, that sort of goes to lockouts or barring the door or changing the locks or in some way creating it so that you cannot use the premises. Those things can only be done through an eviction proceeding. They can't put an eviction proceeding or a 3-day notice before the government order expires. And they can't, if you ended up filing a bankruptcy petition, they cannot proceed with an eviction proceeding as well. So there are a number of landlord no-nos that are still going on, and those are not allowed. So we are at the end of my presentation here, which is concluding with, you have to be creative, you have to have goodwill, and with those two things, the parties hopefully can come to a viable solution that allows both parties to survive and come to some economic success. Although, you know, everyone's going to struggle in this time. And you have to think and remember that few are going to survive unscathed in this crisis, because this truly is a crisis across all sectors of our economy. So we have to really work together to preserve the relationships and minimize the issues and avoid unnecessary losses. So again, this is a crisis of when no one's causing, and it is tough times for everyone. Trying to work with a landlord is not going to be easy, and it's scary, and it can be threatening and fearful. But working again with information and trying to be honest in the approach and show efforts on what you're trying to do are important. So I do want to give a case study on one thing. I'm counseling a tenant right now who is a fitness studio, and the landlord was a retiree with no debt, who had zero understanding of the tenant's situation. So insisted that all rent must be paid for every month. And the fitness studio owner said, well, I had to shut down mid-March. I've had zero revenue since that time. And so, you know, on a partial opening, I can only bring in 6 clients at a time, whereas before I could have 15 people at a time. So, you know, here's what my revenue situation is, plus I'm 3.5 months behind on rent. So the two of them went back and forth and back and forth. And the fitness studio owner showed some revenue projections to the landlord, but the landlord was basically stonewalling the fitness studio owner. So they were not able to come to any agreement at all. And the fitness studio owner last week surrendered the premises and said, I can't do what you're asking me to do. And so here it is. So, you know, not every landlord is going to be willing to work with the tenant, and not every tenant is going to continue in business because they simply can't if they can't you know, pay the rent because the revenue is upside down. So it's that one doesn't have a great ending, but it has to do with the communication and the one-way street aspect that some tenants are going to experience. It's not a perfect world out there, and we have to work with our landlords, and hopefully the people on this call and most tenants are going to have some ability to work with their landlords. So anyway, I'm open for questions.
Thank you, Nancy. As a reminder, we have the opportunity to ask questions through the Q&A function at the bottom of your screen, at the top of your screen if you're on mobile. So a couple questions we've already received. Can you talk about CAM fees, and in particular, how CAM fees can either be increased and or deferred under the state eviction moratoriums and other actions already taken?
So camp fees in most cases are considered part of rent. So it's just another component. In fact, in most leases, they're classified as additional rent. So camp fees can be both utilities, taxes, management fees, maintenance, and most recently, some building owners are going to pass through things like, you know, the looting repairs, because those were not covered by insurance in most cases. So if somebody has to repair a lot of glass and doors and other common area issues, those expenses are probably going to be passed through, and they may be passed through all in one lump sum. So some landlords are going to try and do that, and that's perfectly legal under most leases. And a landlord does have the ability to absorb those if they want. It's one more accommodation, just like accommodating partial rent. So it is something that I think that's worth asking for if they can give some accommodation on that. So that would mean the landlord would be absorbing some expenses that would normally be covered by the tenant, and in essence is a loan if they're expecting tenant to pay it back later, or is forgiveness if they are if the landlord is absorbing that.
Thank you. And then we have another question here about specifically ADA and retooling your business. What legal requirements of businesses are needed to stay compliant with ADA accessibility during business closures?
So I'm not sure that anything has changed with regard to ADA accommodations while businesses are open for business. If you have a partial opening or you're doing a different kind of storefront now, so that you're doing takeout or delivery or curbside pickup, those kinds of things, I'm not aware that any standards have been relaxed or changed, or there's a moratorium on any sort of enforcement of ADA. ADA cases are generally brought by handicapped people who are not able to obtain access to certain premises. So it is possible that somebody might bring a claim on that basis right now, but I'm not aware of any sort of change in the law that allows somebody to defend it based on the government orders. Now, there might have been something in one of the government orders, but I haven't seen anything come out about that. So I would probably have to look into it some more to see if there's anything special, but I haven't heard of any special ADA exemption during this business partial opening. And it seems to me that most of the businesses that do curbside or whatever have been able to accommodate any kind of customer that's coming to the door in the same fashion as they were before. In some cases, because there's more circulation room among tables and things like that too. So in some cases it's better.
Well, thank you, Nancy. There are no other questions submitted at this time. This webinar has been recorded and will be posted to downtownsac.org/COVID-19. You can also find additional resources and links to local and statewide guidance, grants, loans. As a reminder, August 8th is the deadline to apply for the latest round of Paycheck Protection Program funds, and other grants and links, again, available at downtownsac.org/COVID-19. Thank you, Nancy, and thank you to our attendees.
Thank you. And I have a little link at the end. We do a lot of business alerts and labor and employment alerts. So as small businesses or any kind of businesses, if you want to sign up for our firm alerts, we have lots of good free bulletins that might help you in your operations and cost you nothing. And for us, we like to share the knowledge as it comes out. So feel free to go to our website and sign up for our bulletins.
Thank you.
Thanks a lot.
Have a great week, and we will speak with everyone again soon. Make sure to sign up online.